Having understood the key terms, now let's discuss the process itself. The insolvency and resolution process under IBC can be discussed under two heads, namely Chapter 1 and 5 of IBC. Chapter 1 deals with insolvency and liquidation of corporate debtors, where the minimum amount of default is 1 lakh rupees. Chapter 5 deals with the voluntary liquidation proceedings of a corporate person who has not committed any default. Before stating the procedure, let me try to put forward the essence of this elaborate procedure in simple words. The essential idea of this process is that when a corporate entity defaults on the debt, its control shifts from the shareholders or promoters to a committee of creditors who have 180 and now of course 330 days in which to evaluate proposal from various players about reviving the company or taking it into liquidation. Taking this thought forward, let us first talk about insolvency process under Chapter 1. For convenience, the process is divided into different steps. Step 1 is the existence of default. Where any corporate debtor commits a default, a financial creditor, an operational creditor, or the corporate debtor itself may initiate CIRP in respect of such corporate debtor. Step 2 is the initiation of CIRP. As stated above, this can be done by financial creditors, operational creditors, or the corporate debtor itself. Let's talk about the initiation of insolvency proceedings by each one of them. A financial creditor may file an application for initiating CIRP against a corporate debtor before the adjudicating authority, that is NCLT, immediately when a default has occurred. Here, default includes a default in respect of the financial debt owed not only the applicant himself but to any other financial creditor of the corporate debtor. So, let us say if the corporate debtor has taken loan from 3 banks and the default has occurred only towards bank 3, then not only bank 3 but even bank 1 can also file an application to NCLT for insolvency. The financial creditor shall along with this application furnish record of the default, the name of the resolution professional to be proposed as IRP, and any other information as may be specified by the board. An operational creditor on the occurrence of a default cannot directly go to NCLT but first has to deliver a demand notice to the corporate debtor. The corporate debtor shall within a period of 10 days bring to the notice of the operational creditor existence of a dispute or the proof of payment. Even after 10 days of demand of delivery notice, the operational creditor does not receive the payment or notice of dispute, the operational creditor can file an application to NCLT to initiate the CIRP. The corporate debtor also may apply to NCLT for initiating the process of corporate insolvency resolution. In such a situation, the corporate debtor shall have to get a special resolution passed by its shareholders in case of a company, or a resolution passed by at least 3/4 of the total number of its partners in case of LLP, as the case may be. The adjudicating authority, that is NCLT, shall within 14 days of the receipt of this application ascertain the existence of a default from the records of an information utility or on the basis of any evidence furnished by the financial or operational creditor. The NCLT on receipt of such application may accept it or reject it. Where the NCLT is satisfied that the default has occurred and the application is complete, it will admit such application, otherwise it may reject it. However, in case of rejection, the NCLT gives a period of 7 days to rectify the application. The CIRP shall be set to commence from the date of admission of the application by NCLT. Step 3 is the appointment of IRP. The NCLT shall appoint an IRP within 14 days from the insolvency commencement date. The IRP shall be the one as proposed by the financial creditor. When the application for insolvency is made by operational creditor, then the NCLT shall make a reference to the board for the recommendation of an insolvency professional who may act as IRP. The CIRP has to be completed within a period of 330 days from the date of admission of the application. The moratorium period will also begin from this date. During this period, the board of directors of the company stands suspended and the promoters have no say in the management of the company. However, the IRP can seek cooperation from the management in managing day-to-day affairs of the company. The IRP shall conduct the entire CIRP and manage the operations of the corporate debtor during this entire period. Step 4 is the decision to resolve insolvency and is probably the most crucial stage. After his appointment, IRP makes a public announcement of the initiation of the CIRP. A call for the submission of claims by the creditors is also made. The IRP shall, after collation of all claims received against the corporate debtor, constitute a committee of creditors or COC. The COC shall comprise of all financial creditors who will have voting rights in proportion to their claims. Where the debtor company has no financial creditors, then the IBBI shall specify the constitution, composition and powers of COC. The IRP shall conduct the first meeting of COC within 7 days of its constitution. The COC in the first meeting, by a vote of not less than 66% of the voting share of the financial creditors, either decide to appoint as the IRP as a final resolution professional or to replace him by another resolution professional. The next step is to approve or reject a resolution plan. In doing so, the resolution professional invites feasible and viable resolution plans from eligible and credible resolution applicants for the resolution of the insolvency of the corporate debtor. On receipt of the resolution plans, the resolution professional examines each one of them to confirm if they comply with the requirements laid down in the code and submits the same for consideration of the COC. The COC may approve a resolution plan by a vote of not less than 66%. The resolution professional then also submit the resolution plan to the NCLT. If the NCLT is satisfied with the resolution plan, it will approve the same. After these approvals, the company will be restructured and revived and continue as a going concern, otherwise it will go into liquidation. Now, this simply means that if the creditors still see a possibility of revival of the debtor, they will want it to continue as a going concern. However, if the creditors are of a view that they want to take an exit from the business of the debtor, they will opt for liquidation. On passing of the order of liquidation, resolution professionals shall act as the liquidator. The NCLT can order liquidation on other grounds also, such as resolution plan not presented in prescribed time, or if it is not as per rules, the COC demands liquidation of the corporate debtor or violates the terms of the resolution plan. The last and final step is of liquidation. This stage comes when all the efforts to revive the corporate debtor as a going concern has gone waste and no other option except liquidation is left. in case of liquidation, proceeds from the sale of the debtor's assets are used to repay its outstanding dues in the following order: fees of the IP and other costs related to the resolution process, secured creditors and worker dues, employee wages, unsecured creditors, dues to government, any other remaining debt, and then last the shareholders. This particular way of distribution of assets is popularly referred to as waterfall mechanism. Another option for a corporate person is to liquidate itself voluntarily, provided it has not committed any default under the provisions of Chapter 5 of the IBC. A corporate person will be eligible to opt for voluntary liquidation under IBC, provided it fulfills the following two mandatory conditions. Either the company has no debt, or that it will be able to pay its debt in full from the proceeds of assets to be sold in the voluntary liquidation, and the company is not being liquidated to defraud any person. Voluntary liquidation is an expeditious process for winding up the affairs of the company without much complications or compliances. Since learning is a continuous process, in this context, the government is further strengthening the IBC by making amendments to it in order to increase its effectiveness and remove anomalies that exist in the code. Some of the important amendments brought in the year 2018 and 19 are: first, now the home buyers are to be treated at par with financial creditors, which means that now even the home buyers can initiate insolvency proceedings against the defaulting builders. Additionally, now they will also have representation on COC and a guarantee to receive a certain amount if the real estate company goes into liquidation. This amendment is particularly significant in the backdrop of increasing number of defaults by builders in delivering the houses to home buyers. The voting percentage in the Committee of Creditors for routine decisions has been reduced from 75% to 51%. However, the voting percentage in important and key matters such as appointment of the resolution professional, approval of the resolution plan, and increasing the time limit for insolvency resolution process has been reduced from 75% to 66%. This amendment aims to expedite the decision making process. The court now allows the withdrawal of a resolution application submitted to the NCLT before a resolution plan is submitted. This decision can be taken with the approval of 90% of the Committee of Creditors. This exit option gives a second chance to the corporate debtors to make good on the default made to the applicant even after admission of application by the NCLT. The lenders may consider taking this route in cases where they believe that recovery value can be maximized through a route other than IBC. Another key amendment is to specify that the bankruptcy resolution or liquidation arrived at under IBC is binding on central, state and local governments to whom the bankrupt firm may owe dues. This will prevent authorities, including income tax officials, from questioning a rescue plan adopted in a court-monitored process. The IBC Amendment Act 2018 has prohibited certain categories of persons such as undischarged insolvents, willful defaulters and persons who are the promoter or in the management or control of an eligible person from submitting the resolution plan. Another major amendment is that now the court seeks to ensure timely completion of insolvency resolution process cases within the newly set deadline of 330 days, including the litigation stage and also the judicial process stage. The deadline was earlier 270 days. Now if any of the parties has to go to courts, can go to courts, but all this needs to be done in 330 days. If you fail to adhere to the deadline, then what happens? Well, liquidation happens. And it is this fear of liquidation that is expected to instill discipline among the various stakeholders to adhere to the timelines. Promoters and related parties have been disqualified from bidding to ensure that undesirable candidates do not participate in the bidding process. However, MSMEs, given their special place in the economy, have been kept out of this provision. Thus, MSME promoters can bid for their enterprises which are undergoing CIRP provided they are not willful defaulters, providing a big relief to MSME industry. It was also clarified that a resolution plan may include provisions for the restructuring of the corporate debtor by way of merger, amalgamation and demerger. This step will provide a major boost to the merger and acquisition industry.
So, from the discussion so far, I believe that you have got sufficient understanding of the IBC framework. Now, in the light of the circumstances which prompted the need for the introduction of IBC, let us discuss now, does IBC offer any ray of hope? Indeed, introduction and implementation of IBC offers a great potential for a bright future of the Indian economy with a strong corporate lending and investment culture. It is expected to curb various limitations of the previous framework which were hampering the growth of the Indian economy. It has many key prospects which are vital for a progressing economy. First of such key prospects is the Insolvency Resolution. Resolution of insolvency is a unique feature of IBC which was missing in the previous insolvency regime. Before the introduction of IBC, winding up of entity was the only legal option available in case of insolvency. One would agree to the fact that businesses not only generate employment, but they also create economic growth. The resources consumed by businesses belongs to nations at large. Thus, the waste of business resources tantamounts to the waste of national resources. Thus, IBC offers a mechanism to revive or settle the business entities suffering from insolvency situation without causing damage to the economy. IBC requires that the first attempt should be made to bring the entity out of the state of economic distress through a viable revival plan like corporate debt restructuring or mergers, etc., without the need for winding up of an entity. Another advantage offered by IBC is a time-bound resolution process. Before the introduction of IBC, it took companies about 4 to 5 years to dissolve their operations. Generally, by the time the entire process was over, the asset values used to get eroded with very little left for distribution. Now, with IBC setting time restrictions on insolvency resolution process, the entire process can be completed in less than a year's time. It has raised immense hope of faster recovery of debts and also imbibed a stronger sense of trust in lenders and investors. Yet another plus point of IBC is that it has paved the way for major power shift from the hands of shareholders and debt holders to creditors. Historically, the entire process of insolvency and liquidation has always been in the hands of the shareholders and debt holders. Often, the promoters of the company themselves participate in the bidding process and reacquired the same assets at nominal values, thus making the entire liquidation process futile and leaving the lenders outraged and helpless. IBC has made every possible attempt to curb this fallacy. Now, Once the insolvency resolution process is initiated, the board of directors of the company stands suspended and the promoters do not have any say in the management of the company. Also, the resolution plan to be effective has to be approved by the committee of creditors. Further, promoters are prohibited from the bidding or participating in the sale process of the assets of the company in the event of bankruptcy order. It helps in making the whole process a lot more reliable and transparent. The process also allows a company to make a fresh start with a new set of promoters and healthier balance sheets. With the introduction of IBC, every debt-stricken company is trying its hand at debt restructuring or an internal restructuring or putting up its distressed assets on sale for potential buyers. With this developments has come a huge boon to the mergers and acquisitions industry. Now, having talked about various potential advantages which are sought to be offered by IBC, it is the time to have a look at the report card highlighting the performance of this code in the direction of attainment of its objectives. According to IBBI report, 2,162 corporate debts have been admitted into corporate insolvency resolution plan since December 2016 till the end of June 2019. Out of these, 174 have been closed and 101 have been withdrawn. As many as 475 cases have ended in liquidation, while the resolution plans have been approved in 120 cases. As reported by ratings firm CRISIL, bad loan recoveries from the 94 cases resolved through IBC by fiscal 2019 was at Rs 70,000 crore, posting a recovery rate of 43% and was twice the Rs 35,500 crores recovered through previous resolution mechanisms such as the Debt Recovery Tribunal, SARFAESI Act and Lok Adalats. Also, the recovery rate for these 94 cases is twice their liquidation value. Not just that, the code has instilled a significantly better sense of credit discipline amongst the borrowers. As per a report available on the IBBI's website, almost Rs 2.02 lakhs to 3 crores of debt pertaining to 4,452 cases were disposed of even before admission into the IBC process, as the borrowers paid the amounts in default to the creditors. Problem of escalating NPAs of banking sector has also been addressed by this code. There has been a substantial decline in new accounts coming under NPA category. CRISIL estimates that the banking sector's gross NPA has declined to 9.3% by the end of March 2019 from 11.5% the year before. It is also estimated that this will further go down to reach 8% level by March 2020. That shows a definite improvement in the lending and borrowing behavior in the country as driven by slower accretions to NPA loans and faster recoveries from the existing NPAs. All this has led to improvement in India's position in the World Bank's ranking also. India has jumped by several ranks in the ease of doing business ranking. From 100th rank last year, today India stands at 77th position in the World Bank's ranking. But despite of all these positive signals, resolution timelines remain an issue of concern in the success story of IBC. While the average resolution time for cases resolved through IBC is 324 days, which is much better as compared with 4.3 years earlier, it is still above the 270 days timeline initially set out in the code. By the end of June 2019, there were 1,292 cases outstanding under the IBC, of which resolution in 34% of the cases was pending for more than 270 days deadline. Significant delays also trigger liquidation. Also, there are a few big ticket accounts for which resolution has not been finalized for over 400 days. Nonetheless, one can expect to see that this problem will also be gradually tackled with timely amendments made to the code.
After having understood the intricacies of the IBC, the question that naturally comes to our mind is that whether this piece of legislation, touted as one of the biggest economic reform in the country after GST, has actually been able to address the issues and problems that it was meant to provide a solution to. Before discussing this, let me share with you an excerpt from the address which was given by Honorable President of India, Shri Ramnath Kovind, to the joint session of Parliament on 20th June 2019, so as to give you an idea about the government expectations from the code. He said, and I quote, "Insolvency and Bankruptcy Code is amongst the biggest and most impactful economic reform undertaken in the country. With the coming into force of this code, banks and other financial institutions have been able to settle directly or indirectly an amount of more than rupees 3,50,000 crores. This code has also curbed the tendency of willfully defaulting on loans taken from banks and financial institutions. The IBC has thus brought a paradigm shift in the recovery and resolution of stressed assets of corporate debtors by empowering the creditors. Since its implementation, the code has helped improve the governance framework, which has been reflected in the improvement of India's ease of doing business ranking. While IBC has been a landmark regulation addressing the concerns of all the stakeholders, some challenges do remain. Adherence to the IBC timeline, burden on NCLT to resolve large number of cases, clarity on priority of claims between operational and financial creditors, limited number of information utilities, cross-border insolvency, group insolvency are some of the major challenges that needs to be addressed under the IBC. Probably the biggest challenge among all is the ever increasing number of legal proceedings which are putting pressure on the NCLT and NCLAT. Time sensitive resolution is a cornerstone of the IBC. The delays in insolvency process affect the value of the asset, causing loss to stakeholders. To address this concern, the government is taking sincere steps to augment the strength of NCLT by inducting more members. Further, enhancement of the strength of NCLAT will also greatly assist in the process. Even the cross-border insolvency regulations need to be urgently notified. Non-recognition of Indian laws in overseas jurisdictions and vice versa has created certain challenges. It also leads to uncertainty amongst foreign investors on recovery procedures. As per Economic Survey 2018-19, it is important for investors, banks and companies alike to know what is going to happen when things go wrong from a financial perspective in a particular country. Most sophisticated economies have well-developed cross-border insolvency laws. In this regard, India has initiated the steps to make a law on cross-border insolvency issues. Once enacted, this law will help in increasing foreign investment. The Economic Survey also draws attention to the issue of group insolvency. Presently, the insolvency of different companies belonging to the same group is dealt with through separate insolvency proceedings for each company. Recognizing the need for a legal framework To deal with insolvency of group companies, the RBI has recently set up a working group under former SEBI chairman Mr. UK Sinha to recommend a complete regulatory framework to facilitate insolvency resolution and liquidation of debtors in a corporate group. All in all, the IBC seems to be in its elementary stage. Since its implementation, the IBC have achieved some large gains and some concerns needs to be addressed through. The government is continuously evolving and bettering the provisions of the code by bringing in amendments. The fact of the matter is that the code remains one of the success stories in India's economic reforms and continues to develop as it gains maturity. The code has been successful in making a behavioral change in the way repayment of debts are viewed and treated by promoters and management. Now, the creditors are not chasing debtors, rather it is vice versa. The debtors are now paying their dues at the slightest signs of distress to avoid crossing the red line, as they know that once they default, they will be taken to courts and thus will be out of management. In fact, it has been observed that once the petition is filed with NCLT, many debtors are actually paying their dues at a pre-admission stage, which is a kind of out-of-court settlement. Many insolvency cases had already been resolved and many more are at the verge of resolution. All these changes would take India from among relatively weak insolvency regimes to becoming one of the world's best insolvency regimes. This will be the real virtues of IBC. To conclude, I quote a line by the IBPI chairman. By liberating the entrepreneur from failure and releasing resources from chakravyuh of inefficient defunct firms for continuous recycling coupled with improved availability of credit, the code has changed the narrative from hopeless end to endless home. I welcome you all to join this exciting journey of endless hope. Thank you very much for being a patient listener.